Number 9, Oddo versus Queens Village Committee for Mental Health for Jamaica Community Adolescent Program. Thank you.
May it please the court, my name is Amy Weissman. I represent Queens Village Committee for Mental Health for Jamaica Community Adolescent Program. We request 2 minutes for rebuttal.
2 minutes, Ms.
Yes.
Weissman? Very well.
Thank you. Queens Village, if it's all right, I'll call them that, owed no duty to Mr. Oddo at the time of this assault. Queens Village duty was extinguished when it terminated the perpetrator, Mr. Valensis, from its program and handed him off to the police.
How did he come to be placed there?
He's placed there by a program called TASK, and it's one of the several units that place...
Was he convicted and sentenced there, or was he sent there as a condition of some plea deal? What were the parameters of his actual placement?
He is sent there before any kind of plea deal or conviction. He is sent there as an alternative to incarceration where he can go, rehabilitate himself, and then after he completes the program is when he would go before the court for any type of sentencing, conviction, or whatever they're going to do with whatever he was charged with at that time.
So there's no determination of criminal liability when he's placed?
That's correct. He's been arrested, but they haven't made any determination as to his guilt.
Okay. Can he walk out the door?
He can walk out the door, but then he will be discharged from our program.
And how does that occur, counsel, the discharge?
The discharge from our program is we notify TASK because that was the referring agency, and we let them know he is made aware upon orientation that he has to report to TASK the following business day, depending on what day it is. If it was a weekday, then it would be that day.
But what's your process when someone is terminated from the program?
Because this was a TASK program, our process would be to terminate him, kick him out. He would then have to report to TASK, and we would, of course, notify TASK immediately that he has been discharged from the program.
But what are your requirements to accomplish that termination of your relationship with him?
We let him know you have been terminated from the program.
And do you fill out paperwork? Do you report to the court? Do you report?
Ordinarily, we would fill out paperwork that would be faxed over to TASK as well as a phone call to TASK. This situation was a little bit different because it occurred on a weekend, and Mr. Valensis had violated not one but 2 of our cardinal rules, which means automatic termination. He had been drinking, and then he was involved in an altercation. Before the altercation, we attempted to send him to the faith intermissionary, the mission, which because it was a weekend and TASK was not open and he had been drinking. But that when he got into an altercation, we called 911, and he was taken by the police and removed from our property.
So the understanding is someone is discharged on a weekend. TASK is not informed until the following Monday, say?
That's correct, Your Honor. If it's a weekend, TASK would be informed 9 a.m. Monday morning.
And that's the understanding of the court and probation and everybody else, that even though they're not supposed to leave, if they leave or if they're discharged for any reason, that's the beginning and the end of your duty is to tell them to report and to notify TASK on the following Monday.
Yes, but in this situation, we went above and beyond our duty because we contacted 911 like any agency or individual is permitted to do and handed him over to the police who removed him.
I'm sorry, I thought you were waiting to send him somewhere else. You were in the process of doing that. Isn't that your policy?
We were in the process of removing him someplace else just because he had been drinking. We could have allowed him to go on his own, but because he had been drinking, we were notifying the interfaith mission. But when he got into the altercation, we called 911.
I'm sorry, just to clarify. So you're saying he was drunk at the time he got into the altercation?
Yes.
Or he had just been drinking?
He had been drinking.
So it's your position if he was drunk and he walked out the door, you wouldn't have done anything until Monday and informed TASK that he was drunk and walked out the door?
That is how it works, yes.
This is an OR release, right? In criminal court, drug court, OR release, and this is a condition of his release that he participate in the TASK program. That's what we're talking about here, right?
Absolutely. If he doesn't participate, then he's subject to
But
whatever.
my
the
point
criminal
is,
judge-
it's an OR release for somebody who's committed a criminal act, so that means they're on their own recognizance, and then they agree to a contract, in essence, with task and the court and the drug and the court, and they say, I'll participate in this, and then after you finish, then you come back, and if you've successfully completed it, then the court will consider that, and usually you get a reduced sentence to either violation or a misdemeanor or something.
That is 100% correct. That's how it
That's what we
works.
got here.
Yes.
So, so this person isn't a prisoner.
Correct.
Right, just like anybody else on OR release, if they're not a prisoner. They've assumed this condition, though, on their release, like any other condition on your release, like, so you can't go out at night, or any other normal kind of bail
You have
condition that
to
might be
abide
put
by
in.
the rules,
Right.
participate in the programs that are offered, attend counseling, whatever.
So leaving the prisoner question aside, then really we're focusing on the gaps in the program referral system when something happens on the weekend, then. You see what I'm saying from
I do see what
from a
you're saying.
liability point of view?
But my client has their marching orders, and they did that, and they took it one step further and called 911, and he was removed from our property from the police. And all of the case law cited by the lower courts, and the lower court, the appellate division and respondent, for example, Fox versus Marshall and Rivera versus New York City Health, they're distinguishable from this case in that, one, you're dealing with medical facilities and you're dealing with medical doctors who have evaluated the patient and who have engaged them in conversation. You're also dealing with individuals who are under their control in the sense that they haven't been discharged from the facility that they're at, whether they're treating outpatient or inpatient. Some of these cases rely on day passes where a doctor said it's okay to give them a day pass and they can go out and they kill somebody, which is not the situation here. Okay, there was no day pass. He had been terminated from the program, nor was there a doctor. These are counselors at an alternative to incarceration. There was no doctor providing any kind of professional judgment. The duty was extinguished as soon as 911 was called. He was terminated from our program, and he was removed from our property.
You mentioned earlier, I think in response to a question by Judge Stein, that he, or maybe Judge Rivera, could walk out the door. In other words, he could go AWOL.
Correct.
And you would follow the same, I guess, protocol of, you've already told this person that when they leave the program, however they leave the program, if they're leaving it permanently, that they have to report the next business day to task, and then you would inform task about that.
Correct. They're made aware upon their initiation into the program that if they leave, then they're subject to whatever that criminal judge may do. They've lost their chance for an alternative to
But you're
incarceration.
no longer responsible for them, is what you're...
Correct. To put the onus on my agency to follow up with every single individual who, walked out of the facility or who was released to the police or was released to another, it would be an impossible task.
But
Where
isn't
would
it your position that you don't have any right or authority to keep them from walking out the door?
We do not. They can walk out the door, and our duty is to notify the agency who sent them. In this case, it would be task, and let them know. Thank you very much.
Thank you, counsel. Mr. Isaac?
Your Honor, is Brian Isaac. Sorry, I represent the plaintiff respondent. If I can, I just want to
How
give
do they
you...
have any control if the person who is in the facility can just walk out the door?
Well, I
And
don't...
they can't stop them? That's it, they have no authority to do so.
Judge Rivera, I'm happy you brought that because I don't agree with that. So let me deal directly with that if I can. And let me give you the page references as well, okay? Page 83 of the record, paragraph 23. This is Mr. Cottingham. Now, Mr. Cottingham had very, very limited knowledge of what was transpiring. If you read his deposition, which I know you did, he answered, I don't know, more than he answered, I know, probably 70 times, but we'll leave that alone. Question: are they free to leave the facility at any time? Answer, no. Carry over to page 87, then they go into the particulars. Paragraph 4, question: the one exit that is not, and this gets to my adversary's point too, so I'll deal with both of them. The one exit that is not an emergency or fire exit, is there somebody posted at that exit to prevent residents from walking out? Answer: when you say prevent, what do you mean? Define prevent for me. Question: control access of getting in or getting out of residence? Answer: no. No one can physically control anyone entering or leaving the building. Question: are residents allowed to leave the building through that main entrance or exit? Answer: only with staff approval. Now, I will absolutely agree.
Yes, but that would mean they wouldn't be discharged, right? Isn't that, yes, the only way they can do that is if we approve it. But once they walk out without our approval, they're out of the program and we don't have control. At least that's what I thought I heard counsel explain.
And I understand the point.
And why isn't that aligned with what you've just read on the record?
Because when they're saying that they can walk out, this is an alternative, as Judge Fahey said, it's an alternative to prison. What we're doing is we're taking younger people with substance abuse, and by the way, he failed task twice before. We're trying to make sure they're not hardened criminals. There's no bar there, there's no gun there, there's no person there who's going to shoot somebody, but they're not free to leave. It's the same thing as the federal prison system where they talk
Well,
about...
they're not free to leave without consequences. The question is
Correct.
whether or not they can stop them. And her position is we can't stop them. There are consequences if they leave without permission.
That's true. And my argument is not that they should supplant the police. I know that Judge Sachs in his decision went a little far and said it's almost a plaintiff's recovery, and I know my adversary has said that that's not my position at all. My position is that you should do here what you did in the Davis case. This is a question of when they come, and I'm not saying they don't have the right.
But in Davis, at least in Davis, we knew who had to be warned. It was the patient who had to be warned. And as you know, I didn't agree with Davis.
Yes,
but
I know.
That's the law.
I read your dissent.
So we knew who had to be warned. Here, if we were to accept your argument, how wouldn't whoever had to be warned depend on the circumstances of the moment? In this case, you say it should be the police. What if the police weren't called? And are we imposing a duty when the police are involved, but when the police aren't involved? I mean, to me, it seems like
Judge Stein, if I
there's
can,
just no limit to this.
If I can even use Judge Sachs's dissent, which I didn't actually, should have read the page a little better for you. It's a very limited duty. Tell the police, this is a person who's here. This is our system. We take him to a mission. They didn't do that.
But here, the police were called. But wouldn't we discourage them from calling the police if we imposed a duty when they called the police, but not other? If he walked out the door, who are we going to warn? But if we call the police because we're concerned about something, then we have this additional duty. It just doesn't make sense to me.
They've said what the duty is, not me. Brian Isaac doesn't mean anything. I don't even do criminal work. They said it. If you look at their...
They said the duty was to notify task on the next business day. And just to follow up on Judge Fahey's question, what we have here is a person that was released by the court, and presumably the court took into consideration his background, that he had failed task before, whatever he was charged with, whatever his criminal background was, and said, you know what? We're confident enough that this guy is going to play by the rules, so we're releasing him, but he's got this duty. How is this any different from somebody in his position who's told to abide by a curfew of his parents? I mean, what, you know.
Let me ask you both, let me deal both ways. The police, which you're concerned about, and the non-police, which you're also concerned about, and you should be. When the police come, the police get a 911 call. They have absolutely no idea who Mr. Valencias is. And the argument below, as adumbrated in Judge Sweeney's decision, was that they should have known.
What if the police took him into custody, and then decided to release him an hour later? Then what's the obligation?
We have never said, and I am not saying, that JCAP has the authority or the duty to override the police. That was never our claim.
So if the police were to come and they were to tell him, there was evidence that they told the police officer, he's in violation, he's being discharged. What's the authority of the police?
Well, all you would have to do, all JCAP would have to do to satisfy their duty was to say very simply, this is a person who's out on this program. He violated the conditions of the program. Our position is that we would take him to this intermediary faith mission.
Where does that duty come from, though, Mr.
Sorry?
Isaac? I'm trying to figure out where that duty comes from.
Well, it's simple. Actually, it comes directly from the Davis decision. Let me read it to you. I mean, it's almost the same thing. Quote, this is at 26 New York 3rd, 577. Defendants are the only ones who could provide the proper warning. In this case, JCAP's
Yeah, you know,
the
the only problem is I don't know if I'm reading Davis the same way you are, Mr. Isaacs.
Well,
You know,
I got a problem then, Judge.
Yeah,
because you
I
wrote
think
it.
you do, because in fairness to you, I didn't want to sit here and not say anything, but I don't know if I'm reading it the same way you are. Let me tell you why, though, anyway. First, I see Davis as a duty to warn patients who injure a third party of the effects of medication. And secondly, specifically in Davis, we say there is no duty to prevent the patient from leaving the hospital. And that, the language that you're quoting talks about the development of duty, and that's true. And I stand quite strongly behind that in the development of this duty, but we tried to be quite careful in distinguishing and limiting Davis to a particular circumstances and particular set of relationships. This is not a medical relationship. They don't have that kind of relationship here. And so I don't think Davis provides the grounding that you need. When I'm looking here, I think the question I ask myself is, what duty is the appellate division attempting to impose here? First, are they attempting to impose a duty that hold Valentis in custody? They can't be doing that.
No, I don't think so.
And you aren't arguing that.
I am not.
No, so the second point is do they have a duty to tell the police that he's in task and that he's either got to be detained or transferred to another facility? Well, that's a closer question. I think that's where you would land. Am I right about that?
100%.
Okay,
And
go ahead and make your argument then. Because it's hard for me to see what legal authority they'd have it all here to hold Valentis against his will. They have no legal authority. So the only question is if there's a civil duty, so.
Right, and actually, it's not just me, it's Mr. Cunningham. Look at what he says on 133, paragraph 9 of his affidavit. I didn't say it. JCAP was under the impression, I don't think you can get summary judgment under the impression, but leave that alone, that Mr. Valentis would be taken to the police station until such time as his probation and task officer were notified of the situation. That's a straight duty to warn. Also, Judge Sachs referred to a piece of paper that was a task form.
I'm sorry, Mr. Isaac, I'm back to
Yes.
warning the police, that this person is in task? Or that they already know why they're there. The police were called because he violated the rules of this facility. And you're saying that once the police arrived, that the facility had to say, this person is in task, so you have to do something with
Not just
him?
not that he's in task, even more specific. Let me, if I can, Judge Abdul Salam, we keep talking about this as being kind of a minor thing. He's in task the third time for something that's not too minor, at least to my way of thinking. Put a gun to someone's head and said, get me money or I'm going to blow your head off. That's not a minor thing. So all that they had to say was, he's in task, we have this procedure, and if you look at 387 and 389, they don't say he's not dangerous. They say he is dangerous, and his danger is augmented when he's drunk. So let me give you a ridiculous...
And then what's the point? They're going to take him to the precinct? What are they going to do?
To tell them either take him to precinct or contact task or take him to Faith Mission.
If this had happened on the Monday, let me try to differ. If this had happened on the Monday, and they discharge him, but he walks out the door, and they call task, is it your position that they also had to call the police?
No. If it was a Monday, they didn't. The police are involved because it's a weekend. So that's an
So if they had called task on Monday, it would be fine.
That's right. But that's in accordance, if I can, Judge Rivera, with their own duties. Look at 316 of the record.
But if it was a Monday...
Sorry?
And if it was a Monday, and your argument is that this happened within a half an hour of his leaving, then having warned the police, or if it was Monday, you say they don't have to warn the police, they just have to call task. So how would that have prevented this from happening?
Because this notion that he can, even if I lose the case, I don't want to lose it on this fact. The notion that he's just free to go out and he gets a free pass till Monday isn't in accordance with the record. Task gets notified. Let's say that this person didn't have a home. He just can't walk out and go anywhere. If he was in prison and he
what should
committed
they
a
have
crime,
done, Counselor?
They should have given a note. They should have told the police he's in the program, there's a potential danger. We would have taken him to Faith Mission or contacted Task. That's all they had to do.
What basis would the police have? Listen, normally, what can the police do? They can either arrest you. Nobody's bringing charges against them. They're just saying getting them off this facility. So they're not doing that. So they could detain you, but on what basis would they detain him? They have no right to detain anybody. The police can't just say, you can't even force them to maintain, to keep them in their own facility under the OSAS rig. So how could the police detain the kid in any way? So in that context, basically what they can do is remove him from the scene unless they see a criminal act in front of them.
But there was a report, there was a 911 report that he was involved in a fight and he was drinking. So that's not legal.
But nobody said it. Nobody was signing any complaint for any criminal
No,
charges.
I'm not suggesting that they were, but that's not the point. The JCAP shouldn't be able to I'm sorry, I see my time is over. Can I answer?
No,
You may.
just go, I'll let you answer it, but you see what I'm saying? What you're saying is you want the police to determine there's been a violation of his bail
I
conditions.
just want the police to do exactly what JCAP would have done for the protection of the public for someone who would otherwise probably be in jail.
I see.
Because the public is still innocent and they still have a right to be protected. And I get that it's a very, very good thing, and I believe in it, that you shouldn't try to make young people hardened criminals. But there's a corresponding duty to the public who's sitting out there not doing anything wrong, not to give someone a free pass in something like this. And an oral modification that should take, an oral warning that could take 25 seconds, I don't think is too great a leap to have.
Thank you, Counselor. Ms. Weisman?
May it please the court. Respondent can't have it both ways. If this had been a Monday and we discharged him and didn't call the police, we'd have to notify task. Who's to say that this wouldn't happen? But then our duty would be extinguished? We went above and beyond. We notified the police and didn't just discharge him to the public.
Well, you had a duty to notify the police, didn't you?
We had to, no, our duty was to discharge him from the program, and our duty was to notify task, and in this case, it would have been the next business day.
Did you have some internal rule that if somebody breaks a cardinal rule of your program, that they get discharged? But if he assaulted one of your participants, co-participant, would you call the police?
Well, in this situation, he got into an altercation, is what he did. And that is why we called the police. But our rule, whether you break a cardinal rule or you're discharged for another reason, is it's discharge and you notify task. So if this had happened on a Monday and we didn't call the police, counsel is arguing that our duty would have been extinguished. But here, because it happens on a weekend, we didn't just
But if he's on the premise, he violates your rules, he's on the premise, I don't want to go. Are you calling the police to have him removed or arrested because now he's trespassing, because he's broken one of the rules and he no longer is able to be on the premises?
Potentially, but if this was a weekday task,
So
would be
what was
open.
the 9/11 if not to have him removed?
The 9/11 was to have him removed from the
To have him
premises in this
removed because
situation.
he was, at that point, I assume you're arguing he's trespassing.
Of course, and also because he had engaged in an altercation with somebody else, and we felt that it was better to call the police in an emergency like any other homeowner or agency would do in a situation that was similar. Also, Mr. Cottingham's intent has nothing to do with this. Mr. Cottingham wasn't there that day, and whether he believed he was going to be in police custody or escorted off the premises doesn't matter, because as Judge Sachs said in his dissent, what authority does Queens Village JCAP have in telling the police what to do? The police are trained. They're responding to a 911 call at a facility that's an alternative to incarceration. Even if we had given instruction,
What's
who
in
says
the record to clarify, or what's in the record that demonstrates what you call, the reason you called 9/11, what the police did, that they took him into custody? Where is that established by the record?
In the incident report, it says the police, 911 was notified, the police came, and they escorted him off the premises, or the exact
Argument
words.
is the escorting is the equivalent of they then took, the police were then responsible for him because they're physically removing him from the property.
Exactly.
Which is what you wanted.
They removed him from the property. So what Mr. Cottingham's intent was is absolutely no merit here whatsoever. Thank you, Your Honors.
Thank you, Counselor.